event. So, the Supreme Court of India gave a landmark verdict on 7th of November, 2022 upholding 10% economically weaker section, EWS, quota for reservation in higher educational institutions and government jobs at initial level for those other than backward classes, SCs and STs. But why is this judgment landmark? Let's delve into the issue gradually. It simply means that something is fixed or reserved for someone, just like we have in trains. In our discussion, reservation is like positive discrimination or an aspect of affirmative action. So, special privilege is provided for fixing seats in educational institutions or vacancies in jobs for a particular category of persons. Is there a constitutional basis of reservation? Yes, under Articles 14, 15 and 16 the scheme of reservation can be derived. It is based on the premise that Article 14 promotes equal treatment among equals only and steps can be taken for the benefit of disadvantaged sections of society. The scheme of reservation currently exists for OBCs, SCs and STs in education and government jobs. If reservation is existing, why is there such hue and cry about this 10% EWS reservation? Well, reservation is often criticized by common people on the ground that it is eating out from the share of meritorious candidates and handing the same to lesser meritorious candidates. So, reservation in general is criticized especially by those who are deprived of this benefit and have to face open competition for fewer seats or vacancies. To be specific with this EWS reservation issue, major criticisms are choice of economic criteria against social disability criteria for giving reservation, exclusion of OBCs, SCs and STs from this benefit and breach of 50% ceiling in giving reservation as mandated by Indrasani judgment. Now, what is the stand of the government? Well, government is arguing in favor of giving reservation to EWS category on the basis of Article 46, E, DPSP. This article obliges the state to take steps to promote educational and economic interests of weaker sections besides other things. So, what is the judgment of the Supreme Court? The Supreme Court has held that EWS is a distinct and separate category and thus economic poverty can be a ground for giving reservation. Similarly, on the issue of excluding OBCs, SCs and STs from availing this benefit, court-held reservation can be denied to one section, simply on the ground that it doesn't face disabilities like other sections of society. For example, a poor from upper caste may not face social discrimination like scheduled castes but still they can be given reservation. On the issue of 50% ceiling giving reservation, the court held that as EWS is a separate category, this limitation is not applicable on EWS quota. In simple language, it means that the 50% limit on giving reservation is applicable only for OBCs, SCs and STs and not on the new EWS criteria. However, the issue of a ceiling of 50% in giving reservations is still sub judice. Many people claim that a 50% ceiling on reservations is essential to protect the equality of opportunity for unreserved sections of society. What happens now? The effect of the judgment on socio-economic equality is to be seen in the future, but it is clear that this judgment paves way for acceptance of the fact that now reservations can be claimed on the basis of individual deprivations too, as against only on class backwardness, as initiated with the passage of 103rd Constitutional Amendment Act. Rest.